Lordship, if it can be said that since the matter is pending before the Honorable Supreme Court, so the parties may be given liberty to mention us and when the matter is disposed, and during the that course, then all those proceeding before the MPSC may be.
See, but if the matter is not directly related to the case before the Supreme Court, then the court cannot pass a blanket order in that sense.
Because they are relying heavily on the.
They may rely.
Your Lordships may simply sit and let adjourn the matter for 4 weeks. In the
I think
meantime,
that would be the proper
Yes,
course.
my lord.
Otherwise, it will complicate
Yes, my lord.
things.
Yes, my lord. On my request, let it be adjourned for 4 weeks. my lord.
The department would be confused, the parties would be confused, and the court
The councils also
cannot
be
extend
confused.
that that jurisdiction.
On my request.
Okay,
So
fine.
then 4 weeks, Your Lordship.
On prayer made by the petitioner, this is matter up to 4 weeks. In the meantime, the interim order pass will continue until the next date fix.
Obliged.
10 and 11, my lord.
Saya ketua Yuru, you are respondent. Respondent number 4 has entered appearance through Mr. Bikram, Learned Counsel. Fine.
Obliged, Your Lordship. 5, 6, 7.
Lordship, the item number 5, item number 5, Lordship, is up. And 5, 6, 7, these are the analogous matters. The only issue involved in this case, whether the Hindi post
Hindi
is a
teacher is-
sanction post. So in this case, Lordship, Mr. Sheikh, he has prayed, another prayer is also there, challenging my appointment. And that I got some papers to substantiate my claim that at that point of time, the petitioner was not qualified. Because the school came under SSA in 2010, he got the 10+2 degree only in 2012 and graduated in 2016. And as per the government notification, the qualification provided 10+2. So if I am allowed to file one additional affidavit to bring these records, these documents on records.
But if this fact is known to you,
No, it was
at that point
not
of time?
known. Recently, only last week, the client brought these papers and given to me.
Okay.
And they have also not disclosed about the
You are
qualifications.
the managing committee, or you are the,
I'm the
private
respondent.
respondent.
6. Managing
Private
committee
respondent.
and private
or you are
respondent.
also.
Yes, because I am likely to be affected if any order is passed. To the
Managing committee, then you should have known this.
No, these
facts.
papers,
They have appointed me.
it
They
is
have
by
selected
the
me.
government.
You have appointed him.
Yes.
Uh,
My lord, our case is not that we are pressing for Hindi. We are only that there are 3 posts, we may be accommodated.
This
within the 3
letter
posts.
issued by the government, it was
Within the 3 posts. That
not
is
known. Now
my-
we came to know.
We are not saying that government should grant extra for Hindi post. That is not the.
It is the government who issued this notification. We were not aware, but now we came to know under the SSA what are the requisite qualifications. The requisite, even the government affidavit also, it is not enclosed. The requisite qualifications.
or not close.
So not enclosed. It's nowhere in the. Just we want to just bring it across so that.
So the matter will be called up.
Yes, sir.
I beg to mention item number 12. I am for the respondent here, Lordship. I
Appearing
I have
on
taken
behalf of
consent.
the petitioner.
Any objection?
I have taken consent from her senior. Lordship.
How long?
So let this matter be taken up after 1 week.
What is this matter? Maintenance?
Maintenance.
You are the wife.
Yes.
Play 2 weeks, Lordship. 2 weeks, that matter will be hard.
2 weeks.
Have some next week.
Maintenance, we have to. You see, we cannot just keep it. If it involves interim maintenance, or if it involves are you receiving maintenance now?
No, sir.
Huh?
Yes, sir. Sir, I'm not instructed.
You should know these facts. on prayer made by the respondent, not objected to by petitioner. This is met after 2 weeks.
Chief, in item number 3 and 4, that Mr. S. Abraham, he is for the state respondent, Lordship. So he is not available today.
Abraham is not the counsel.
Four is that matter we have heard it laying only the issue of award.
No, three.
Your Lordship, presenting to the petitioner, Your Lordship.
For 3.
I'm representing for the petitioner on item number 4.
Item number 3.
Number 4, Your Lordship.
No, we are on item 3.
3 also, 3 and 4, Lordship.
They are not connected, Mr. Sheikh.
Yes.
Make mention one at a time. You may be there
Yes, I know
as respondent, but petitioners are different.
Yes, Lordship.
Who's appearing? Petitioner, Mr. Sangreso. He's not here. Let the matter be called up and we'll see.
Okay.
Now, come to 4. What is required? Mr. Khan, you are in this case. So what is, this matter has been practically heard. What is it?
We were supposed to file an affidavit bringing on record the award part. That we have brought in record.
Okay, so what remains?
We've already filed our written submissions, Your Lordship. Concluded our arguments as well.
Okay. So you file your written argument, have you?
Lordship, if Lordship requires, we file it.
Do it, since they have done it. Then a counsel for the petitioner has the state respondent seeks some time to file the written argument allowed. This is matter after 2 weeks.
Right, Your Lordship.
Please, Your Honour. Your Honour, I beg to mention item number 3, Your Honour. My senior is not well, Your Honour. He's hospitalised, Your Honour. That's why he can't be here today.
I have no objection, Your Lordship. I'm appearing on behalf of the petitioner.
On plea made by the respondent, KHADC, not objected to by petitioner. This is matter after 2 weeks.
Much obliged, Your
Please, Your Lordship, I beg to mention item number 13.
Yes.
Your Lordship, I pray that 2 weeks may be given.
You are for?
I'm for the petitioner, Your Lordship.
On plea made by the petitioner, this is matter after 3 weeks.
May please, Your Lordship. Lordship, I beg to mention item number 9.
I think we have concluded the hearing.
Concluded, yes.
Then
Lordship,
what is,
Lordship, I am supposed to file written argument.
you file yours.
Body is on a record, Lordship. Lordship, I'll file within the course of the day, Your Lordship. As with regards to the compilation of judgment, Lordship, I'm praying that I may be allowed to file on Monday.
Lordship, 3 to 4 occasions you have taken time to file written argument.
Why? What's taking you so long?
Lordship, let him file in the course of the day.
Too busy.
In that event.
I'll give you 1 week's time. But let this be the last. On plea made by the respondent seeking time to file the written argument. Matter is adjourned. This is after 1 week.
Supplementary cost list, item number 1.
My lord, I have filed the submission, written submission. My lord.
You have already filed yours.
File, Your Lordship.
Petitioner has filed the synopsis of the written argument. The respondent Nehu has also filed the written argument, synopsis of the written argument, which is on record. Accordingly, this matter is now posted for judgment, reserved for judgment.
Daily cost is item number 1.
This will be the 3 cases.
So you are for respondent?
Number 5 and 6.
5 and 6. Mr. Qureshi, at this point of time, matter of 2018, at this point of time, you've come with new facts.
It is not a new fact. In fact, the petitioner could have disclosed the qualification who has not disclosed. And recently, we could obtain his qualifications. What is his qualification?
How is it material to the...
Materials to that...
To the case?
Suppose if he is claiming that I should have got this post. So by the time when the school was taken over by under the SSA in 2010, he got the 10+2 degree in 2012. And he graduated in 2015 or 16. In my case, I graduated in 1996. There is one of the things which is not brought on records. I'll just file a very short affidavit just to bring this document on records only.
And then he has to respond to it. So then
that, in fact, that is not material, Lordship. What happened, that was not the reasons for replacing me. Because I am a contractual teacher. When the school was taken over by the SSA, 3 posts were taken. So the managing committee have selected the 3 teachers. And other teachers, they are working as a SMC, school managing committee teachers, and we are under the contract. Then all throughout we have been working. In 2016-17, Lordship, there is a notification from the government saying that we are going to implement the RTE norms. That as per the RTE norms, there is no post of Hindi. Then after that notification, Lordship, the schools which were taken in the year 2010, in Garo Hills almost 100 schools were taken, Lordship, by the common order. In most of the schools, after receiving the notification from the government, they have adjusted the teachers who were appointed as Hindi. Most of the schools have adjusted, and they have given the subject as per the subject assigned by the RTE norms. But in my case, Lordship, instead of adjusting me, they have the managing committee.
See, Mr. Sheikh, number 1, is it incumbent upon the authorities concerned, maybe the managing committee, to adjust your assignment? If it is under the statutes or rules, then you have a case. But if it is discretionary, then you have no cases.
Lordship, here, Lordship, it is not only my case. It is almost 100 schools.
See, whatever the case may be, see, what happened to the 99 cases, we don't know. But you are fighting your case on the basis of your particular facts and circumstances.
Now another
that would be the only consideration.
Yes, now another legal issue, my lord. All throughout, my status is contract till 2018. This is the government affidavit they have filed. From 2010 to 2018. So law is settled. One contractual employee cannot be replaced by another contractual employee. it can be replaced by regular.
See, that is also one thing, Mr. Sheikh. You know, as far as contractual appointment is concerned, it's common knowledge. Any Tom, Dick, or Harry will know that it confers no right. So you cannot claim as a right to be appointed.
I am not seeking
or
as
to
a
be
regularization.
regularized until it is done by due procedure. So if your contract is terminated,
not terminated, Lordship.
Whatever the case may be, if it is not terminated, if it is likely to be terminated, you have no say. You cannot say that one contractual teacher was replaced by another. I don't think that will also be
But here only issue when the school was brought under SSA, what are the prerequisite conditions?
That of course.
What are the documents?
Some other aspect of the matter can be looked into.
What are the documents? Suppose now there are 4, 5, 7, 8 teachers are there. Out of 7, the 3 teachers were selected for SSA. Now all others are not SSA. Now when the school was taken under SSA, what are the documents they have executed and what are the documents they need to produce so that they claim that they are the SSA supported teachers? That is also one of the vital aspects. Now 2018 all of a sudden coming and saying that no, I am also SSA, because SSA, the school was not taken in 2018. The school was taken in 2010. When the school was taken, what are the prerequisite conditions? What are the documents?
Mr. Shea, I don't think you have a case. Based on the premise that you are a contractual appointee, I don't think there's any consideration. But anyway, matter will be heard. Mr. Kushi, I don't think we'll need to go into that. He's a contractual appointee. So question of qualification would not come.
No,
if it is a permanent appointment, then
it's a contractual.
So we'll hear the matter then.
Maybe taken up by next week. No?
2018 matter.
There are 3 matters, similar issues involved.
This matter, you see, that argument has been. See, this court has accommodated all the parties concerned, keeping in mind that maybe some, common issues are there. So matter was tagged together. Yeah. But not necessarily that it should be, heard altogether. Should be heard. Yes. All the cases should be heard simultaneously or at the same time.
Yes.
We will hear the matter on the merits of each case. So you're not prepared to do why?
Just after
See, look at the time. We have all the time.
I'll just read my affidavit. I'll come.
So 1 week then.
1 week.
This is Lordship. Next on 25th to 28th, I'll not be here, Your Lordship. So Lordship will kindly excuse me if it can be done in the first week of August. Any date, Your Lordship.
So after 2 weeks.
Hello.
On preamble by the parties, this is matter to 2 weeks.
In fact, Lordship, the private respondent is seeking for time. I'm not seeking, Your Lordship.
No, it's okay.
It's okay.
Either he seeks time or he seeks time, it makes no difference. Everyone will be affected. Fine, 2 weeks.
I think 6 also
same.
Then 6, 7 will go.
Same order.
Hello.
Apply, Your Lord.
Item number 8.
My lord, this matter was finally heard and was fixed for filing our respective.
Yes. Have you filed yours?
I'm filing now.
And who's for the state?
Mr. Kharmi is there. Any state?
He was here just now.
No, he wasn't here.
He was not here. Oh, he's not here.
Since he's there, so I'm.
Give him.
Kharmi.
Petitioner has filed the written argument. However, the state respondent has not yet filed the same. Has not yet filed its version of the written argument. Accordingly, let the respondent file the written argument within the next date fixed. Let's just matter up to 2 weeks.
Replayable.